Not necessarily the way I would have written it up, but the long-awaited Duncan v. Bonta opinion has dropped from the Ninth Circuit en banc panel. That was our challenge on the standard capacity magazine ban in the state of California. There's 174 pages to get through here. Let's talk about it. Hey everybody, welcome back to the channel today. It has been long awaited once again, but we do have a decision in the Duncan v. Bonta case. That is our challenge against the constitutionality of standard capacity magazines here in the state of California. Looks like history's repeating itself once again, but to walk us through it, we have brought back on volunteer president of CRPA. That is Chuck Michel. Chuck, thanks for being with us today.
Oh, it's a pleasure, fellas. Big news today.
Yes, absolutely. So, guys, as always, be sure to like, share, and subscribe to these videos. We're trying to get this information out as quickly and effectively as possible. This is going to be a big one, potentially causing a lot of movement in litigation. So please like, share, and subscribe. We want to get this as far and wide as possible. So, Chuck, now is normally when I would be asking you if you could give us a rundown on the history of Duncan. I feel like some of it is incorporated here. I wanted to read the summary from the opinion itself. By the way, guys, link in the description below. 147 pages of majority opinion, dissenting opinion, and some dissenting and concurring opinions as well. A lot of legal talk about magazine and the Bruen decision. After the video, please read the whole thing. There's a lot of good and a lot of bad information in there. We're going to talk about some of that today. But from the summary, here we go. Buckle up, guys. This one is a bit of a long one. The en banc court held that the California law banning the possession of large capacity magazine comports with the Second Amendment, reverses the district court's contrary conclusion, and remanded with the instruction to enter judgment in favor of the Attorney General of the United States or of the state of California. Employing the methodology announced in New York State Rifle and Pistol Association v. Bruen, the en banc court concluded that California's law comported with the Second Amendment for two independent reasons. First, the text of the Second Amendment does not encompass the right to possess large capacity magazines because large capacity magazines are neither arms nor protected accessories. Second, even assuming that the text of the Second Amendment encompasses the possession of optional accessories like large capacity magazines, California's ban on large capacity magazines falls within the nation's tradition of protecting innocent persons by prohibiting especially dangerous uses of weapons and by regulating components necessary to the firing of a firearm. Accordingly, the en banc court remanded this case to the district court with the instruction to enter judgment in favor of the California Attorney General. Dissenting Judge R. Nelson agreed with Judge Bumate's dissent that the majority opinion to reverse the district court on the merits flouted Bruen. The majority's decision also spurned the statutory procedure for an en banc proceeding because, as explained in his dissent from the order filed concurrently with the opinion, this en banc court lacked statutory jurisdiction to decide this new appeal. Dissenting Judge Bumate, joined by Judges Ikuda, Nelson, and Van Dyke, would hold that nothing in the text or the country's historical understanding of the Second Amendment warrants California's magazine ban. Applying the Bruen framework, California's magazine ban is presumptively unconstitutional because the plain text of the Second Amendment protects the possession of magazines capable of feeding more than 10 rounds. California failed to overcome the presumption of unconstitutionality where California failed to identify a historical analog that was relevantly similar to a ban on these magazines. Accordingly, he would hold that California's magazine ban is unconstitutional. Woo! Okay, so break that down for us here a little bit, Chuck. You have some of the majority opinion there, some of the dissenting opinion, and a little bit of what happened during the oral arguments in the Ninth Circuit en banc panel with Judge Van Dyke just going off about whether or not this panel should take the case at all. After the first glance, and I know that there's going to be a whole lot more interpretation of this 147 pages to come, but at first glance, where are we with this opinion?
We are going to the Supreme Court is the answer to that in a nutshell. And it's an opportunity for the Supreme Court to set the record straight, to clarify Bruen's methodology, to stop the shenanigans that lower courts, in particular the Ninth Circuit, have been playing with how to interpret Bruen and applied the Bruen methodology correctly. And they could, I mean, there's several progressively inclined courts that have bent over intellectually backwards to try and twist the Bruen and the Heller rulings so that they can uphold all manner of gun control laws. And the Supreme Court now has the opportunity to emphatically set the record straight and correct the misinterpretations that these lower courts have been making of the Bruen decision. Now, that is the short answer. We're going to SCOTUS. We've been there before. The Supreme Court had been asked to consider Duncan. Remember, this case was filed in 2017. And this oral argument that we just got a ruling on today was made a year ago. So they sat on this for a year. I fully expect that the Supreme Court, and this case also is in a good procedural posture because this is from a judgment from Judge Benitez down in San Diego. Not a preliminary injunction ruling, which is one of the reasons why the Supreme Court has not been taking what otherwise would be good vehicles for a Second Amendment review, because they were up on preliminary injunction rulings rather than a final judgment. This is a final judgment. This is the right procedural posture. The record was developed, and it's all the evidence is in. And so what the Ninth Circuit has done is narrow what is considered an arm. Remember, the Bruen test says you first figure out whether or not the language of the Second Amendment applies, the right to keep and bear arms. What is an arm is something that's being debated right now about suppressors, about magazines, about other gun parts. In Illinois, they're arguing about whether they can ban parts or repairs. So the threshold question is a magazine, a arm, is what the Ninth Circuit spent most of its time doing. Then the second question is, assuming that the Second Amendment language covers the item, the gun or firearm part or firearm accessory or whatever, or ammunition or whatever it may be that is being banned or regulated, then is there some historical analog law, some law that was passed for the same reason and was put into effect in basically the same way? So that's the how and why test from Bruen. Is there a historical law that that lines up with and indicates that the founding fathers would have tolerated this modern law back in 1791? And that's really secondary in the Duncan decision about the historical analogs, but they got that wrong too. They grasp the flimsiest of analogs, and like they're basically saying now that, well, they've regulated dangerous things before, so this is a dangerous thing, so they can ban magazines because there's historical precedent. But before they even really got to that, the serious first threshold question is whether or not a magazine is an arm. And they got into a big debate about what's an accessory and what isn't. And Judge Van Dyke's video illustrates this point beautifully, because so can they ban grips? Can they ban different types of sights? Can they ban different types of triggers? Where all those things could be considered accessories and not a fundamental core part of an arm. And again, folks should watch Judge Van Dyke's video. I can't do better than that to explain how dumb the state's arguments are here about why magazines are not protected by the Second Amendment's plain language.
Yeah, that is a fair point. Jacob, if you could put the link for Judge Van Dyke's video in the description below. Maybe a little bit more homework on top of the 147 pages to read, but it really kind of illustrates the disparity of knowledge that you can see between the judges. Judge Van Dyke is extremely knowledgeable about firearms, which is why he's able to put up those arguments where, as you can see by the majority opinion, there is certainly a lack of knowledge that those arguments have to come from here. You did kind of touch on the testing that goes with the Bruen test. In Judge Bumate's dissenting opinion, it was kind of touched on that they strayed from that altogether. I know something that we've been talking about since Bruen dropped in 2022 is that the Ninth Circuit and some of these federal district court judges were going to be working to sidestep Bruen as often as they can. I wanted to read this, Jacob, if you could pull it up. In Judge Bumate's dissent, it's literally titled The Return of Interest Balancing. It reads like this. The majority upholds California's magazine ban despite Heller, McDonald, Bruen, and Rahimi. In doing so, the majority rejects the Supreme Court's Second Amendment framework and reads the amendment as it wants. First, the majority haphazardly establishes two Bruen tests, the so-called more nuanced and unnuanced approaches. If that sounds confusing, it is. In fact, it's so confusing, the majority largely abandons its own creation mid-opinion. Second, rather than examine historical analogs for the similarity with California's regulation, the majority simply cloaks interest balancing under the guise of tradition. So in the Ninth Circuit, we've returned to the old days of judicial policy making that the court has gone out of its way to end. Now, I guess kind of a two-part question here. We've been talking about the courts wanting to do this. This becomes a little bit more flagrant. I guess really it's only one question. Does something like this make the Duncan case really ripe for the Supreme Court to want to take?
Yes, because this is lower courts, and in particular the Ninth Circuit, which is the most frequently overturned circuit court, even though now it's almost 50-50 with the previous Trump administration's Ninth Circuit judicial appointments. But the Ninth Circuit has notoriously been overturned. So that's factor one. But factor two is that they're thumbing their nose at the Supreme Court. And the Supreme Court, it's not the first case that did this. So I think the Supreme Court really wants to get in there and basically straighten some of these lower courts out. But again, some of those have been going up on preliminary injunctions rather than on judgments, which this is. So it's got this Duncan decision has several things going in its favor. Also, it's been up there before. They vacated the Ninth Circuit's previous en banc ruling from several years ago because it was wrong, and Bruen came down. And so in light of Bruen, they said, reconsider everything. The Ninth Circuit took it back. Then the Ninth Circuit sent it back down to Judge Benitez. We've tried this case in front of Judge Benitez twice. And there's an awful lot of work involved in that. And then it went back up. So it went from the district court win in years ago to a Ninth Circuit 3-judge panel win, then to the en banc loss, 7-4, which is the same numbers we got this time around. Then to the Supreme Court. The Supreme Court vacated the loss, sent it back down to en banc. En banc sent it back down to Judge Benitez. Judge Benitez tried the case again. It went back up. The en banc panel grabbed it, and that's where there's a sideshow, a separate opinion issued by the Ninth Circuit that said it's proper for the en banc panel to take it back without going through a 3-judge panel first. But that's basically a red herring issue, legal procedural issue. And so now we've got this ruling from the en banc panel, which we will ask the Supreme Court to look at again. But with that much history, the Supreme Court is going to recognize you can't get a more thorough record than what there is, in this case. Now, there are other cases, though, that the Supreme Court's been asked to take. Snopes is the semi-auto ban case that the Supreme Court has recalendared several times for consideration. There's an Antonok, which is sensitive places. But but one thing I do want to make people aware of, the beauty of having a judge who knows a little bit or a lot about firearms. This happened in Illinois too. Judge Van Dyke is the most recent example because of the video that he did. It shows he knows how to shoot. He knows how a gun works. Many judges don't. They wouldn't know the business end of the gun from the other end. But for example, in Illinois, we had a district court judge who really knew firearms. The Judge Benitez in San Diego knew something. If they know something about guns, then they can see through the baloney that the state is trying to sell them. But the big thing is, if you can ban a gun because the government can ban a gun because they decided it's dangerous. Every gun is dangerous. Every firearm is dangerous if it's in the wrong hands. The things that make a firearm more accurate, and they would say that makes it more dangerous, or have more rounds, or have a red dot sight, or have better grips, or have a modified trigger. All of those things make a gun more effective as a target shooting or self-defense firearm. But if misused, they make the gun more dangerous because if it's in the hands of a criminal. Now, criminals don't generally go out and shop for a gun that's been modified. They get whatever the first gun on the black market is, or whichever one they can steal. That's their weapon of choice. But law-abiding citizens who want to have an effective self-defense weapon or a self-defense firearm or a target shooting firearm, or for that matter, hunting or whatever else, they will individualize the gun. That's one of the problems with the whole roster in California is that people have individualized needs for individualized custom firearms customized for their needs. And the state doesn't want to allow any of that. They want to basically dumb it down. It's going to come down to, Barney Fife on the Andy Griffith show. He was allowed to have one bullet and he kept it in his pocket, and that's all you can have. So that's the state would be fine with imposing that kind of a restriction.
Yeah, and the age-old argument is that the criminal is by definition not going to pay attention to the laws. They're going to break the laws.
Well, yeah, that's the threshold flaw in all of this, which is that you can buy. There's plenty of 10-plus round magazines out there on the black market or otherwise that if a criminal really wants to get that, they can.
Well, let's talk about movement here for a second. So this case is going to SCOTUS. Is this also kind of the spark that lights the fire to heating up litigation for California altogether? We had some of our big cases. We've got the May case. We've got the Rohde case, where we're kind of assuming that those panels are waiting on Duncan to move forward. We've got the Boland case, which the panel literally came out and said, we're waiting for Duncan to move forward on this. Is this kind of the spark that sees those other lawsuits start to move forward in the Ninth Circuit?
Yes, and while you mention those cases, let me give a hat tip to the National Shooting Sports Foundation for helping to support the Boland case, and the NRA for helping to support the Duncan case. Both of those organizations deserve credit for partnering with CRPA to help keep those cases moving along. But now all those cases, they don't deal with whether or not a gun on or off the roster is an arm or a sensitive place. That has nothing to do with what arm you can or cannot take into the sensitive place. It's not the threshold Second Amendment language of the Second Amendment question. It's the secondary question. And ammunition has already been found to be an indispensable component, not a mere accessory, to the extent that accessories can be banned, which I don't think they can, because it's like banning parts. So all of those cases, I think, are going to be opened up for more briefing or for an opinion, depending on what the status, how far along those cases are. And so, yes, we will now be in full-blown litigation mode. So please help support CRPA to keep all those cases, get all those cases back in motion and try and win those. And also we have our gun show case in the Supreme Court right now. Duncan is headed to the Supreme Court. Now's the time to help support CRPA to keep all those cases moving along.
Certainly, and we are going to be here to follow along on all of those. I suspect that we will have you back soon because there will be a lot of analyzing of these majority and dissenting opinions. Probably want to do a video also when we actually file for this to go to SCOTUS. Any final thoughts on this, Chuck, after first glance moving forward? What could the timeline look like for SCOTUS, and your opinion on the opinion?
Well, we'll be moving right away for the Supreme Court to take the case, because we want to get this up in front of them as soon as possible, because they go out of session in June. So we're going to try and get it up there so they might actually consider whether to take it. They won't hear it this session. So this case will not be heard. Oral argument, if they accept it, won't be heard until the next Supreme Court session, which starts on the first Monday in October. But if we can get something up there fast enough, we might be able to get it into conference and have them decide whether or not to take it and then hear it next year. So that's where we got to run. We got to really, get to do everything we can to get it up there. But the opinion, look, it's not a particular surprise that this en banc panel came down the way it did. It's kind of the way they came down last time. And given the inclinations of some of these justices and frankly, their desire to not have a strong Second Amendment, in part because they don't understand firearms. It's wrongly decided, and it's really, it's mind twisting. It's reasoning. It's false reasoning that they kind of put their thumb on the scale to try and make it come down this way, because they really don't want a strong Second Amendment. And we have to, our job and the other groups that are all fighting in various states to protect and enhance and support and defend and expand the Second Amendment's protections. We're all in the same boat. But really, we're waiting for a Supreme Court case that will basically put the lower courts in their proper place, tell them what they're doing wrong, tell them how to do it right, and then move forward on all these other cases that aren't there yet.
Well, we'll certainly be following along and hoping that that is the case. It kind of feels like the Supreme Court is a light at the end of the tunnel, so long as we can get the cases there. Chuck, I know that you're already a busy guy.
Final thought. This is a historic time for Second Amendment jurisprudence. This is stuff that's going to be studied a century from now. This is part of history. Please help support our efforts. You will be a part of history. We're trying to preserve freedom. We're trying to preserve the Second Amendment. We're trying to preserve the American way of life for ourselves and for our children. So to the extent that you can help us on that mission, would all be grateful.
Absolutely. And I was going to say, I know that you're already a busy guy. These are the frantic times. So thank you for taking the time to come on with us today and walk us through this.
Yeah, thanks for having me, guys. And we'll be back again as the case proceeds and our other cases proceed.
Absolutely, we will. And guys, if you like content like this, you want to continue seeing these videos as they drop from the attorneys who are working on the case, please, once again, be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to the litigative and legislative efforts for the Second Amendment in the state of California. Thanks again, guys, and we'll see you on the next one.